Quality British ABCR, Bramblefinch cocks, Bramblefinch hens, 25 shilling each. Such advertisement was advertised on April 13, 1967, has led a man, Arthur Partridge, to be charged under Section 6, parenthesis 1 of the Protection of Bird Act 1954. This is because he unlawfully offering for sales a Bramblefinch hen. What actually happened? How this could happen? Why? And on what basis he is charged? Partridge vs Crittenden 1968, the well-known English case for establishing a legal precedent in English contract law. This case was held in High Court of England and Wales. The case was heard by the Divisional Court of the Queen Bench Division. This case involved Arthur Partridge as the defendant, Anthony Crittenden as the plaintiff from Royal Society of the Prevention of Cruelty to Animals, RSPCA, and also Mr. Thompson as the buyer of the hen. The story began on April 1967 after the Mr. Partridge put an advertisement in a cage and aviary newspaper. In the newspaper, Mr. Partridge advertising Bramblefinches at 25 shilling each. Upon seeing the advertisement, Mr. Thompson, which is the buyer of the hen, requested by a letter on April 2020, 1967 that the Bramblefinch hens is to be sent to him through the mail. Mr. Thompson paid a check of 30 shillings to Mr. Partridge, and the defendant dispatched the bird by rail mail in May 1st, 1967. Mr. Thompson received a box which is contain the bird inside of it, and the birds are wearing a close ring on May 2, 1967. This was what actually happened and why Mr. Partridge being charged under the Section 6 parenthesis 1 of the Act of 1954. Why? Basically, it's happened because brambling is considered as a wild bird included in Schedule 4 to the Protection of Bird 1954. Therefore, it is considered unlawful to possess for sale or offer for sale Bramblefinch which was not bred domestically. The defendant, which is Mr. Partridge, was found guilty of the offence by the magistrate in his trial. The appellant was fined with £5 and was ordered to pay £5, 5 shilling, advocate's fee, and £4, 9 shilling, 6 penny as for the witnesses' expenses. However, the defendant appealed this conviction by claiming that his advertisement was an invitation to trade. Appeal was made by the defendant. Now the dispute on Mr. Partridge appeal was if the advertisement could be regarded as an offer to sell or if the advertisement was meant as an invitation for trade. The appellant claimed that there was no offence committed under Section 6(1) of the Act of 1954 because the ring was possible to be removed from the bird's leg without any injury, which means that it was not an closed ring specimen. Partridge also contended that his advertisement was not an offer to sell but just an invitation to trade. He stated that there was no direct use word of offer for sales. After going through the appeal process, what would be the court decision? Thus, Partridge found guilty. After looking through the advertisement carefully, defendant, which is Mr. Partridge, was found not guilty, as was charged by the Mr. Crittenden. According to the lawyer, Ashworth J. stated that it is not an offer for sale, but instead it is only an invitation to trade. According to the lawyer, an invitation to trade is not an offer for sale made by the seller, but it is made by another party to make the offer. Hence, we concluded from this case, the decision held by the Queen's Bench Division is acceptable. The justification is based on the definition of offer, which is clearly stated under Section 2, Contract of Act. Hence, the advertisement of Bramblefinch made by the Partridge can only be concluded as only an invitation to trade and not an offer. There is no indication of an expression of intention to be bound. Instead, the advertisement is a means which invites or induces one to make an offer. court didn't simply make the decision. The case of Fisher versus Bell was also being referred, as a similar point arose but in a different situation, which is in the Fisher versus Bell case, the defendant displayed a flick knife on the window of his shops next to a ticket bearing the word "Ejector knife for us," which is it is illegal to manufacture, sell, hire, offer for sale or hire, or lend to any other person. It has been stated under the restriction of offensive weapon 1959, section 1, parenthesis 1. On 14 December 1959, the claimant, which is a chief inspector of the Bristol Constabulary of the English Police Force, brought forward information against the defendant, alleging the defendant has contravened section 1, parenthesis 1 by offering the flick knife for sale. The judges at first instant found that the displaying of the flick knife on the windows shop was merely an invitation to trade and not an offer, and thus no liability arose. The prosecutor appealed the judge's decision.